Good afternoon, everyone, and welcome to this week's afternoon program. As you're aware, on a weekly basis, the South African Bar Association hosts a speaker to deal with a legal topic intended to assist young practitioners with training and development, and in so doing, improve the quality of legal practitioners in our courts. This is one of the core values we hold as an organization. It's an honor and privilege to host Attorney Aslam Moosajee, an executive from ENS Africa, which is Africa's largest law firm. I have been acquainted to Aslam for much time now, and I can tell you that albeit his knowledge and that his chair sits in Africa's largest law firm, he is exceptionally humble and always willing to share his knowledge. By way of providing a brief legal background of Aslam, I reiterate, Aslam is an executive of at ENS Africa, which is the largest law firm in Africa. He has acted as a judge of the High Court of South Africa and is also a small claims court commissioner. He specializes in commercial and financial litigation, as well as constitutional and administrative law, arbitration, and mediations. He has advised clients across a wide range of industries, including financial services, education, and media. His experience includes advertising and representing clients in a number of significant disputes, including those resulting to the South African National Credit Act, the Companies Act, and termination of bankers' customer relations. He has been involved in a number of high-profile mandates and precedent-setting cases. Aslam shall be addressing us on a topic titled "The Legalities Pertaining to the Closure of a Bank Account," a topic to be exceptionally interesting in this economical climate. A few housekeeping matters. These sessions are recorded, and we appeal to participants to ensure that your microphones are muted and that your video cameras are switched off. Accordingly, during the address, all participants shall automatically be muted. If a participant has a question, simply raise your hand using the Microsoft Teams platform. During the question and answer session, please restrict questions to the speaker relevant to the topic under discussion and only pose such questions when called upon. Without any further ado, I now hand it over to you, Aslam.
Thank you, Ahmed, for that very kind introduction. Let me start by saying that I don't think any of us should proclaim to be experts. We learn from each other, and I'm hoping that we can make the session an interactive session so that if people have views contrary to my views, please raise your hand and you can share your views with us and we can discuss it and maybe open that up for a greater debate so that we're all better informed after this particular session. I'm planning during the session to deal with a few cases that dealt with the closure of bank accounts and a challenge to the bank's right to close the bank accounts. Thereafter, I'm going to deal with the recently enacted conduct standard for banks, which banks have to comply with from the 1st of July of this year. And that does have a bearing on the closure of bank accounts, and I'll take you through that. In fact, just before that, I also want to discuss two constitutional court judgments, which one has to bear in mind when dealing with the closure of bank accounts. Those two judgments, which is the Pridwin case and the Biedeke case, which I'm sure most of you will be aware of, didn't deal directly with the closure of bank accounts, but I am sure that there are principles in those judgments that we can all bear in mind, because often when there is a challenge to the closure of bank accounts, the challenge is on the basis that it's unfair or unconstitutional. So it's important to then bear in mind the law as was stated in particularly the Biedeke case. But the Pridwin case also has a bearing on the question of whether or not banks are obliged to give a customer a hearing prior to the closing of the customer's bank account. So the landmark case relating to the termination of bank accounts at the bank's instance is that of Bredenkamp versus Standard Bank. The citation is 2010 for page 468. It's an SCA judgment. And in this particular case, the SCA held that it would not be fair to impose an obligation on the bank to retain a client because the other banks may refuse to bank that particular client. In that case, also interestingly, the SCA held that the bank may, absent a contrary provision in its contract with the customer, unilaterally terminate the agreement, and generally its motives for the unilateral termination are irrelevant. The Bredenkamp case has since been quoted with approval in a number of subsequent cases. The first one that I am aware of is an unreported judgment in Hlongwane versus Absa Bank Limited. It's a Pretoria High Court judgment. This particular judgment did not deal specifically with the closure of the bank accounts, or there wasn't a challenge to the closure of the bank accounts at that stage. Instead, there was a request for information under the Promotion of Access to Information Act. And Mr. Hlongwane had requested all records relating to Absa's decision to close his bank account. The Pretoria High Court dismissed the application and held that Absa's bona fides in closing Mr. Hlongwane's bank accounts could not be questioned. In doing so, the court quoted with approval the Bredenkamp judgment and also recognized that Absa had no obligation to retain a client whose monitoring in terms of money laundering measures would be more onerous when compared with the benefit to Absa if it continued banking Mr. Hlongwane. So often, if you are involved for the banks and there is a challenge to the closure of the bank accounts, don't just rely on the bank saying, well, it causes business risks for us or it causes reputational risks for us. Try to go deeper and establish, have there been suspicious transactions? Has that resulted in reports to the Financial Intelligence Center, for example? And the more you can demonstrate that, I think the easier it becomes to justify the closure of the bank accounts. Now, you may say to me, but why are you saying we need to justify the closure of the bank accounts when the SCA in Bredenkamp held that the motives generally for closing the bank accounts are irrelevant? That is the case, but there is a footnote in the Bredenkamp case which opens the door for a challenge by the court making the point that the bank cannot act capriciously or arbitrarily in closing the bank account. And I think if, for example, an individual can prove that the bank has acted contrary to our constitutional values. So, for example, a bank decides that because I'm Muslim, they're not prepared to bank me, or a bank decides that because I'm gay, they're not prepared to bank me. I think that goes to the root of the Bill of Rights, and under those circumstances, I think the court will not tolerate the closure of the bank accounts. Then the third case to bear in mind is the case of Minister of Finance versus Oak Bay Investments and others. This was the case that had been launched by then Minister Pravin Gordhan against a number of Gupta-owned entities. And then there were various banks that were cited as respondents in the particular application as well. At the time, Mr. Hawa, who was quite instrumental in managing the affairs of a number of the Gupta-owned entities, was putting pressure on government officials to intervene and try to prevent the various banks that were closing the accounts of the companies that were associated with the Gupta companies. And in this case, a full bench of the Gauteng High Court, even though they dismissed the minister's application, they confirmed that the bank may terminate the relationship in its discretion on reasonable notice, provided that the reasons for terminating the relationship do not violate a public policy or constitutional values. In this case, the court also quoted with approval the Bredenkamp case. I'm not sure whether I gave you the citation. The citation of that case is 2018 3SA 515 GP. The next case to then look at is the judgment of Annex Distribution Pty Limited versus Bank of Baroda, 2018 1 SA 562 GP. Just Fabricius had summarized important principles that emerged from the Breedenkam case in that particular judgment, and therefore it's a particularly useful judgment to have regard to. Firstly, he recorded that a bank has a right to terminate a contract with its customer either on the notice period provided for in the contract or in the absence of such a notice period provided for in the contract, then on reasonable notice, and we'll come back to on what reasonable notice is. Secondly, a bank has no obligations to give reasons for terminating this relationship. Its motives for terminating are generally irrelevant. There may be an exception, however, where it is found to be an abuse of rights. There's going to be a change to that I'll come to by virtue of the conduct standards for banks. Thirdly, then, there are no self-standing rights to reasonableness, fairness, or goodwill in the law of contract. Fourthly, a bank is entitled to terminate the relationship with the client on the basis of reputational and business risks, and courts should importantly be reluctant to second-guess the bank's assessment of those risks. And then, irrespective of whether negative publicity about a customer is true, a bank is fully entitled to terminate the relationship with a customer that has a bad reputation. And then finally, the fact that the customer may have difficulty finding another bank does not impose any obligation on the bank to retain that customer. I think the important thing is, if all the other banks are not prepared to bank a particular individual, why then is it fair to expect the banker that originally banked that customer to continue banking that customer when that bank faces reputational and business risks and may also face increased costs in monitoring and in complying with various statutory obligations? On the question of reasonable notice, what is reasonable ultimately depends on the facts, and I often then call for the activity on the accounts in order to see the level of transactions on the accounts, the nature of the business that's being run. If we got some idea of that, you look at that. And that will always give you a good indication of what would be reasonable. Guidelines that are set by the Banking Ombudsman's Office are generally 30 to 60 days for an individual's account and 60 to 90 days for a business account. But those are not cast in stone and will ultimately depend on the facts of each relevant case. Then the two Constitutional Court judgments, the first one is AB and Another versus Pridwin Preparatory School and Others. The citation is 2025 SA 327 CC. And the second judgment is Birka 231 CC and Others versus the trustees for the time being of the Oregon Trust and Others, 2025 SA page 247, also a CC judgment. Now, the central issue in the Pridwin case was whether an independent school is entitled to terminate a contract on reasonable notice without giving the relevant parent and children notice of the termination of that contract. The Constitutional Court unanimously held that independent schools are obliged not to impair a child's right to basic education, and consequently found that an independent school cannot terminate a schooling contract without following fair procedure, which entail giving the children and the parents an opportunity to make representations before the decision to terminate the contract is made. The court sourced this obligation to follow fair process in section 28(2) of the Constitution, which provides that the child's best interests are of paramount importance in every matter concerning the child. Furthermore, Section 29 of the Constitution guarantees everyone the right to basic education. Sorry, not free, just basic education. Even though it was common cause that Section 28(2) imposed obligations on independent schools, both the High Court and the Supreme Court, relying on the Breedekamp judgment, held that this did not entail that the child or the parent had a right to a hearing before the decision to terminate the contract had been taken. The Constitutional Court disagreed with the High Court and the Supreme Court of Appeal and found on the facts of the case that the school was obliged to afford the impugned parents and the children a hearing before the termination of the contract. In arriving at this finding, the majority of the Constitutional Court held that even though independent schools have no positive obligation to provide basic education, independent schools are obliged not to impair a child's existing right or access to basic education. Consequently, the school's decision to terminate the contract without following a fair process was declared to be unlawful, and the court found that the school unjustifiably violated its obligations to the children, and particularly their right to a basic education. Now, based on the Breedekamp case, for a number of years, I have contended that there was no obligation to give a customer an opportunity to make representations before the decision to terminate the contract is made. The question now is, do you now call a meeting with the customer and give the customer a hearing? Or at the very least, do you tell the customer in writing that you are planning to terminate the agreement, but you haven't made a final decision yet, and before a final decision is made, you want them to make representations to you so that you can then make a more informed decision. Most, or I shouldn't say most, a number of colleagues and a few of them from the bar itself have been of the view that there is, by virtue of this Pridwin case, now an obligation on the banks to allow a customer to first make representations. I'm not convinced that that is correct, but I accept that I'm in a minority view on this, and we'll have to see what the court does ultimately with this issue, if this issue is revisited by our courts. My concern with the banks asking customers to make representations is that often the bank will, on the basis of press reports and then tracing back to activity in the bank account, realize that there's suspicions or suspicious activity going on, and then decides it wants to terminate the relationship with the customer. And once this gets disclosed, the customer inevitably would deny that that is the case, and in some instances may give you an explanation that's a concocted version. But there's no way you as the bank can then go and test that, because you don't have the powers of subpoena, powers to cross-examine people, and so it does become difficult. But it's an interesting debate. My view about Pridwin was that it turned on its peculiar facts, and the court was largely motivated by the constitutional right to basic education. Whereas with a bank account, yes, some people says it has an impact of the right to economic activity, but I'm not convinced that that is necessarily so, because in our there's cases that we are aware of where, even though bank accounts have been closed, companies have continued to exist and have used payment agents or other agents or lawyers' trust accounts in order to receive money and pay out money and to continue trading in that particular way. The Constitutional Court judgment in the Mbidika provided clarity on the contested question of fairness in contract law. The majority held that the Supreme Court's finding in Breedenkamp that a court may not refuse to enforce contractual terms on the basis that the enforcement would, in the court's subjective view, be unfair, unreasonable, or unduly harsh remains good law. In other words, if one wants to avoid a contract or the exercise of the counterparty's right under that contract, it is necessary to satisfy the court that the contractual term or the exercise of the right under the contract is contrary to public policy. Since Mbidika, however, a court need no longer be as reticent as courts were in the past to refuse to enforce contractual terms on the basis that they are contrary to public policy. So if there is an argument made on the basis of an enforcement of a term being contrary to public policy or the contract itself being contrary to public policy, then the court needs to make an assessment of that without falling back on the previous position that it's only in exceptional circumstances that a contract would be struck down on the basis that it's contrary to public policy or the exercise of the right under that contract is contrary to public policy. Now, there's then been the Financial Sector Authority, which developed the conduct standard for banks, which all banks in South Africa now need to comply with. And there are relevant clauses in the conduct standards which do introduce some changes for banks, which they're going to have to comply with when terminating relationships with customers or refusing to offer a product to a customer. Clause 9.1 of the conduct standard provides that banks must document, adopt, and implement processes relating to the refusal to offer financial products or services to customers and the termination of the bank's relationship with the customer. This is a new requirement, as prior to the coming into effect of the conduct standard, there was no need for the bank to have a documented process that it implements in regard to the closure of bank accounts. Then clause 9.2, read with 9.1 of the conduct standard, provides that subject to certain exceptions, which we will get to just now, a bank may not terminate the relationship with a customer without providing reasonable prior notice of the withdrawal, termination, or closure to the financial customer. So this is no different to what the current state of the law is. You have to generally, in the absence of a provision to the contrary, provide notice, a reasonable notice to the customer. Clause 9.3, read together with 9.1 of the conduct standards, provides that subject to certain exceptions, a bank may not refuse to provide financial products or services to a customer or terminate its relationship with a customer without disclosing the reasons for the refusal, withdrawal, or termination. Now, this is a new obligation introduced by the conduct standard, as prior to this, while there was some debate, I think the better view was that there was no obligation on the banks to provide reasons for the termination of the bank accounts or termination of the relationship. The final provision to be, in fact, there's two others. There's clause 9.4 of the conduct standards, which provides that a bank may refuse to provide financial products or services or terminate a relationship with the customer without providing the customer reasonable prior notice or reasons if it is compelled by law or it has a reasonable suspicion that the financial product or financial service is being used for any illegal purpose and has made the necessary reports to the appropriate authority. So if you're compelled by law and you've made the reports to the appropriate authorities, you're entitled to terminate without giving reasons. If you have a reasonable suspicion that the account is being used for an irregular purpose or an untoward purpose, illegal purpose, I should rather say, and you've reported your suspicions to the Financial Intelligence Center, for example, then you will be able to terminate on reasonable notice, but you're not obliged to provide reasons for the termination. Then clause 9.5 provides that the contractual arrangements with financial customers must make provision for the types of circumstances in which the contractual agreement may be terminated or withdrawn by the bank. I think this is a particularly onerous provision. I would have preferred it if banks were given the opportunity to deal with this on a case-by-case basis, because you often have very, very different reasons for wanting to terminate the relationship, and you could end up with terms and conditions then that run into many, many pages just because you want to cover each and every possibility. So let's just then summarize. 1, a bank is required to have a documented policy which outlines the circumstances in which it will refuse to deal with the customer or terminate its relationship with the customer, and the process it will follow in deciding to refuse to deal with the customer or terminate its relationship with the customer. Secondly, where a bank terminates its relationship with a customer, it must in most instances give the customer reasonable notice of the intended cancellation, and it must provide the customer with reasons for the cancellation. Whether or not you first give the customer an opportunity to make representations or for an oral hearing, I think is something that the courts will pronounce on as and when this issue arises. I have articulated my view that I don't think there's that obligation, but there are others that think that because of the Printer case, there is now that obligation. Thirdly, the bank is not under an obligation to provide reasons if the bank has a reasonable suspicion that the financial product or service is going to be used for an illegal purpose, and it's reported its suspicions. And similarly, it can terminate if it has a reasonable suspicion that the product or service is being used for an illegal purpose, and that has been reported. And finally, then banks are obliged to make provision for the types of circumstances in which the contractual arrangement or contractual agreement may be terminated. I think, let me stop there so that we can take some questions and hopefully stimulate some of the discussion.
Thank you so much, Aslam, for that informative address. I have now opened the platform for a brief question and answer session. By way of a reminder, participants who have a question, simply raise your hands using the Microsoft Teams platform. Aslam, I have two questions. My first question surrounds the reasonable notice. It is accepted that one of the implied terms of a bank customer contract is that a banker may not cease to do business with a customer except upon reasonable notice. Banks may also not unilaterally close an account in credit without giving reasonable notice. If my memory serves me correctly, this was confirmed in the Joe Shimson vs. Swiss Bank Corporation judgment. It is also accepted that what constitutes a reasonable period depends on the character of the accounts and the specific facts and circumstances pertaining to each case. An example in that regard would be the Prosperity vs. Lloyds Bank, if I'm not mistaken, where in particular 1 month's notice was considered to be insufficient in that matter.
Yeah.
My question surrounds this reasonable period.
Yeah.
The Ombudsman for Banking Services in its publication dated January 2008 constituted, and you just stated it earlier, a reasonable period for, if we take a commercial account, to be between 60 and 80 days, depending on the nature of the account. Now, you have dealt with clients with offices in a number of countries. Such clients hold bank accounts within this country, of which such bank accounts are linked to other bank accounts within other countries. And we both know that the mere facilitation of the migration of such takes a long time. In lieu of such, it is my submission that a reasonable period kept at a maximum of 80 days, I deem that not to be reasonable. What is your submission in that regard? That's my first question. My second question surrounds the banker's guarantees. With reference to banker's guarantee, which is a common form of payment, especially when dealing with a large monetary quantum. If I use an example of a purchase of an item, be it immovable or movable, whose bank issues out the banker's guarantee to the seller, of which the seller in bona fide accepts such bank guarantee and acts in accordance with such by inter alia, affecting the transfer of ownership of the item. Subsequent to such banker's guarantee, the bank, for whatever reason, find merits to either effect a notice or to their client. For example, in my example, the seller. Naturally, this would severely prejudice the purchaser, as the purchaser acted in good faith on such banker's guarantee, which now places the purchaser in a position whereby he's severely prejudiced. What is your comment in that regard?
So let's deal with the reasonable notice issue first. And there's no hard and fast rules. It will turn on the facts of each particular case. But you have to demonstrate that, assuming they gave you 90 days notice, you have to demonstrate the steps you took in those 90 days to find alternative bankers. And one is somebody is prepared to bank you, but they're still going through their own processes, okay? Or nobody else is prepared to bank you. If nobody else is prepared to bank you, then no matter how much notice I give you, it doesn't make a difference. And therefore the argument will be the 90 days is more than sufficient. Nobody's prepared to bank you. If, however, you got 90 days notice and you did absolutely nothing during those 90 days until the last 2 weeks, and then you start scurrying around and trying to find alternative bankers, then I think also I'll have a good argument to make to say, no, they didn't take timeless steps. This is when I told them. I told them 3 months ago. So it will turn on the facts, and often people fall down. Often people will say, no, it's not reasonable. 90 days, in fact, 60 days, not reasonable. I mean, I've seen instances where I call from the bank statements, in order to check the activity on the account. And it seems that the account in question is not even the primary trading account of that particular customer. And the customer is now contending that that's not reasonable notice. That customer has another bank account, is using that other bank account at another bank. In that case, even 30 days would have sufficed. So it will turn on the facts. On your second question on the bank guarantee, remember that usually when the bank provides you with or provides a guarantee at the instance of the purchaser, it will either be sitting with cash in an account, which has been pledged to the bank as security for the cover under that guarantee, or it will take a view on the credit risk of that particular customer. And it will say, Ahmed Jasad, I'm happy that for a 3 million rand guarantee, he will be good for 3 million rand if I have to sue him later because the guarantee is called up. So in circumstances where you're sitting with the cash in an account, if the bank gives the notice to the seller, ordinarily the seller would have the ability to call under the guarantee within that notice period, okay? And then the bank will look to the purchaser, to the cash to the purchaser. But I'm not sure that the purchaser can say it's out of pocket, because the purchaser was going to pay that money anyway for the house. It just means that the money may have been advanced a little earlier than otherwise would have been the case.
Thank you so much, Islam. There's a question from Patel. Patel, you can just unmute your mic and your camera.
Good afternoon, Mr. Islam. How are you doing?
Good, thank you.
I just would like to say thank you firstly for taking some time out of your busy schedule and attending this webinar. It's been rather insightful, and I think I speak on behalf of all the participants and from the South African Bar Association.
Thanks, Mohammed.
Mr. Aslam, with regards to that, to the matter you mentioned earlier, the Breedenkamp and Standard Bank case, you mentioned that the court held that the exercise of a contractual right, which does not involve any public policy consideration or constitutional values, does not have to be fair. Okay. Now, my question is with regards to the warrant of execution in terms of Rule 45.8, when you get a court judgment and then you freeze the bank accounts of the person, obviously the judgment was granted against. Would that Breedenkamp judgment be applicable in that in the matters where you freeze a bank account?
So
because that's against public.
So the effect may be the freezing of a bank account, but actually the word freezing is a misnomer, because freezing denotes that everything comes to a stop. Okay, whereas what the banks ought to be doing when the warrant is served, they ought to be not allowing withdrawals from the account, assuming now that the value of the judgment debt exceeds the credit balance in the account. Okay, what the banks ought to be doing under those circumstances is not to freeze the account, but to place what I call a stop debit indicator on the account. So credits can continue coming into the account, but you can't allow debits going out until such time as there's sufficient funds in that account to meet the judgment debt. And that the bank is complying with an obligation that the rules of court requires it to comply with. So it's not willy-nilly freezing the bank account. It's restricting some activity on that bank account, but it's doing that because the rules of court require it to do so. And if it doesn't do so, then the bank could end up being liable to the judgment debtor.
I see. Thank you so much for your submission. I really appreciate it.
Pleasure. Sina?
There's a question from Sina. Sina, you can simply unmute your camera.
Thank you. Salam, Aslam, how are you?
Salam, good, thank you, and you?
Okay, thanks. Okay, so I'm going to take a little bit of a step outside of banking law and just on principle ask you if it's applicable in a different instance in terms of some of the authority that you cited. Taking Pridwin, and I'm going to give you an example or hypothetically paint a picture, and then you can tell me if it'll apply. Yeah. Let's take healthcare, where it's not contractual per se, but you've got a third-party payer that pays a healthcare provider. So it is a one of the basic rights in terms of healthcare access. If a medical scheme chose to terminate direct payment to a provider of healthcare services without due process or notice having been given, would you say that the Pridwin principles would apply in that instance? That's my first question. The second one is in relation to banks in particular. In the instance where a bank decided to terminate its agreement with a client and stop allowing them to bank, would it be reasonable for that bank to then share its reasons with another bank? And also, as a follow-on to that, my understanding is that when there's some suspected or reasonable concerns around fraudulent activity, that banks are allowed to share information amongst themselves. But would you say that that would be applicable in other instances where, in fact, just on a reasonable suspicion of fraud, for example, medical schemes could share information about providers of healthcare with each other? Do you think that would apply? Thank you.
Okay, so let's just deal with the medical schemes question first. Is my understanding correct, Hasina, that there's no direct contractual nexus between the health provider and the medical scheme? This scenario comes about because there's a direct contractual nexus between the patient and the healthcare provider, and the medical scheme insures the patient.
Yes, that's correct. So there's no contractual relationship between the provider and the medical scheme, but one can argue that it's almost like a case of trade usage or custom, where in fact there may have been direct payment to a provider and then that is unilaterally terminated. So
I mean, the problem with trade usage is not the easiest thing to prove. There's quite stringent requirements that have to be met. You've got to be able to show that it's universally known, and in order for to establish such a trade usage. So I'm not convinced. I think that the medical schemes will say there's no contractual nexus between us and the healthcare provider, or let's say doctor, and we in fact not even obliged to pay the doctor. In fact, we could be paying our patient, and the patient would then be obliged to pay the doctor. We actually helping the doctors by making payments directly to the doctors, so that the patients don't run away with money that we provide to them. Now, I know that there's often the version that the medical schemes act unilaterally and bully the doctors, etc. But there's also another side to the particular story when you sit with a medical scheme, and the side to that story is that the medical schemes face a number of fraudulent claims, and the more of those claims they entertain, the more expensive medical aid become for you and me. So it's finding the right balance at the end of the day. On the second question, whether banks, whether they can share reasons. Firstly, I should say that banks generally don't go around saying, I've terminated so-and-so, and this is the reason I've terminated. They're all generally very concerned about their duties of confidentiality. So you would find, even in instances where a fraud has been perpetrated on you and you can prove that you received an email duping you into paying money into a different account, but it turns out that that account is not the account of the party that you were intending to pay. What the bank will do often is ask you for an affidavit, and may, for a very short space of time, put a stop debit indicator on the particular account in question, but still force you to go to court to get an order compelling that account holder to transfer money back to you. And they're also, very alive to their breach of confidentiality obligations, and so they try not to share reasons. The reality, however, is that whenever there's a challenge, it's often the challenge and the fact that everything gets disclosed in court papers that gives rise to the publicity, and not the fact that somebody closed the account, didn't tell anybody about it. And often when I'm asked by people, listen, somebody's received notice and they want to challenge it, I would say to them, your money is going to be better served in going to find another bank. And go and do your damnness to try to find another bank without saying too much. Okay, and if you find a bank, that's the solution to your problem. If you don't find another bank, then you may face a difficulty, and unless there is some other creative solution that sorts you out, then you may want to go to court.
Thank you, Aslam.
Did I answer your questions, Asina?
You kind of did. I think it's in the second question, in the question around whether there can, in fact, whether there'll be breach. I know that the banks, you say, obviously want to honor confidentiality, but whether there is some cooperation between banks in the instance of fraud, and whether they would be allowed to, and similarly whether that can be transposed into a different environment, like in the medical scheme environment,
yeah.
Or whether the law will prohibit that type of sharing of information.
I think the reality of the situation is that there is sharing of information, or a cooperation between banks in circumstances where they're trying to prevent a fraud from continuing, or trying to minimize the loss pursuant to a fraud. And so they may, under those circumstances, cooperate with each other and share information on that particular basis. but not outside of those parameters. Whether the medical schemes can do it or not, I think is an interesting question, and a lot will depend on the judge you draw, because I can see arguments being made on both sides. The one argument will be that confidential information should not be shared. The other argument will be we need to protect society against fraud and corruption. And the only way to do that is to allow the sharing of this sort of information. I should tell you, I was this year involved in a case where the banks have what they call a REDS system, and that lists former employees that had been dismissed for misconduct or resigned, and after a hearing, there was still a conclusion that they were guilty of misconduct while they were employed with the bank. And somebody tried to challenge it on the basis that you can't continue that after the termination of the employment relationship. And we successfully opposed that application. It's a judgment delivered by Judge Valley. It's Mr. Ngadi, who used to be a senior employee at Nedbank, versus the Banking Association and Nedbank. And Mr. Ngadi was also refused leave to appeal. So it's going to be interesting to see whether he applies for leave to appeal to the SCA or not.
Thanks, Aslam. Yes, I am aware of them, and that is specific to employment relationships, but it is an interesting, I would say, parallel or...
Yeah, I mean, it's a database that keeps information about dishonest people. And, I think the courts have recognized that that plays an important role in the banking industry, where you need to employ people that are of the highest caliber and you can trust it, you can trust deeply.
Thank you.
Thank you so much, Aslam. There are 6 other questions from the participants. However, time does not permit for such, and regrettably, I have closed the question and answer session. However, I am sure that I can say with confidence that you have an open door policy, and for all of those participants that have that heartwarming question that they need to ask you, then they can simply pose that to you. Your details in that regard can be found on the ENS Africa website. What remains is, on behalf of the South African Bar Association, we sincerely thank Aslam Moosajee for his inspiring address and his time, and we foresee working very closely with you in the future. Appreciation to all those that have participated virtually and shall be watching this session at their leisure. These sessions are recorded, and the recording can be found upon the South African Bar Association website, that being www.rsabar.net. I thank you.
Thanks, Ahmad.
Thank you.
Thank you, Aslam.